Hello, everyone, and welcome to our December 2020 Bank Counsel Roundtable. Today, we're going to talk about prepackaged bankruptcies. My fellow panelists are all partners in the Finance and Restructuring Group. Joe Acosta is a partner in our Dallas office. Eric Schnabel is a partner in our Delaware and New York offices, and Peter Nelson's a partner in our Minneapolis office. Eric, take it away.
Thanks, Tom. So just a few preliminary issues. We're going to be here for an hour. If you need any of the materials or so forth, feel free to email the events email. In terms of questions, feel free to email questions or use the chat feature to give us questions, and we're happy to have those in the middle of the presentation. No need to wait to the end. We are going to have a Q&A at the end if we've got time. If we don't get to your question or you think about it later, feel free to contact any of us or any of your Dorsey counterpoints to grab us or grab whoever and ask away. So thanks very much for being here. We hope to do this again real soon, live at some point, hopefully next year. And hopefully my neighbor's dog won't bark during the presentation, which has happened before. But anyway, so this is us. A big thank you to our associate, Karina, who helped prepare these materials for us. And, let's just get right to it. So we basically have 4 substantive sections and a Q&A. Here, we're going to go through the types of restructurings, and these are really balance sheet plan restructurings. We're not getting into sales or those other aspects that occur in bankruptcies and distress situations. We're going to talk about the timelines a little bit compared to a normal case versus a prepack. We're going to get into some nuts and bolts of prepacks, and then we're going to talk a little bit about some case studies, some cases that we're aware of or involved in, and how that played out given the substance. And then we'll have time for questions if you have any. So getting right to the types of restructuring. So what we've laid out here is kind of the 4 different groups that you have in a balance sheet type restructuring. You've got your out-of-court workouts, which, you're in the dark a little bit about what's going on from a public perspective, all the way to the free fall or traditional bankruptcy, where there's nothing prearranged or pre-negotiated or prepackaged, and you just file for some reason and you figure out, where to go from there. And we're going to talk about each one of these 4 individually. So moving to the first category, which is out-of-court workouts. This is a situation in which you've got a balance sheet restructuring, and typically you can do this without the help of the bankruptcy court if you really have key creditors involved and on board. And you can do this through some sort of an exchange offer or, recapitalization or refinancing, some debt equity swap or a swap of one debt into a different kind of debt or convertible or something like that. UCC foreclosures or even sales are ways that a distressed company can do an out-of-court workout. These are really great. Why? Because they achieve the restructuring objective of changing the capital structure of the company, the balance sheet, but you do it in a very efficient way because anytime you can avoid court, it's going to be less expensive and oftentimes quicker. So that's our first type of restructuring. Moving on to the prepackage, which is what we're going to talk about more substantively today. The prepack, that is where you utilize the bankruptcy process, but you do the entire solicitation, plan, voting, everything pre-petition, and then you just show up in the bankruptcy court with all that completed, and you go right into the confirmation process. And this is a scenario that the debtor, in essence, the bankruptcy case can be quite quick. We've all heard stories or seen cases or been involved in cases where the bankruptcy goes on for years. While these cases, these prepackaged cases can go from 1 to 45 days. And we'll talk about timeline a little bit later. But even the prepackaged part, which goes pre-petition, has to comply with all the bankruptcy timelines. So even though you're not in bankruptcy, you still need to comply with those kind of bankruptcy rules so that when you show up in court, you're in full compliance. So that's what a true prepack is. Now, when you look at the next type of restructuring we call pre-negotiated, sometimes people call this a prepack because in this scenario, you didn't do a full solicitation like a true prepack. You didn't file, disseminate the plan and disclosure statement to your creditors, have a voting deadline outside of bankruptcy, and have the votes all cast and ready to go before you file. Here, it's more of you have a pre-negotiated agreement, and then you do that solicitation, plan filing, so forth, post-petition after you filed bankruptcy. One of the key components of a pre-negotiated deal is that the borrower or the debtor to be is going to have the major constituencies of creditors, in an agreement and enter into a restructuring support agreement. And the RSA is a key component because it gives, it's the elements of the deal. It could be a term sheet in terms of the recapitalization, balance sheet restructuring, or it could be, plans, a full drafted plan attached as Exhibit A to the RSA. But it'll set forth those timetables. It'll commit the supporting creditors to vote in favor of the plan. Once it happens, it'll commit the debtor to move that plan forward through the bankruptcy. Usually, always or should have a fiduciary out for the debtor. But the difference between the prepack, pure prepack, and the pre-negotiated is here. You just have the business deal. You're really doing the pure bankruptcy stuff in the bankruptcy case. And that will stretch out, as we'll discuss a little later, the timetable for this, because you have more to do in the bankruptcy case as opposed to the pure prepack. And then finally, the last
Eric, before you move on, you want to talk a little bit about the fiduciary out, what that means? Sure.
So, a debtor is a fiduciary to the stakeholders. And when you're insolvent, those stakeholders enlarge, if you will, the group to include its creditors. And so the debtor has to have an out from the business deal of the plan support agreement, the restructuring support agreement, in case a better deal comes along. So, for example, if there was going to be a debt equity swap, which would allow the debt, right, to gain equity into the new reorganized company, and they filed bankruptcy, and then Facebook or some monstrosity, Apple with more money than anyone shows up, Warren Buffett, what have you, and says, look, I'm going to write a check for money that will take out the debt and give some money to maybe the unsecured creditors or to equity. The debtor has to have that ability to get out of the restructuring support agreement and take that deal because it's better for the enterprise as a whole, even though the lenders who signed the restructuring support agreement might not want that because they might want the equity upside that the RSA has. So that fiduciary out is typically required by the courts. The RSA is going to be approved, typically assumed in the bankruptcy case by the court, and the court was going to want to know that the debtor can pivot and turn somewhere else if another deal, a better deal occurs. And if you think about plans, the debtor files a plan. It can always pull the plan and do something different if a better deal returns because it's planned. Like it has its own fiduciary out when it's proposing a plan. And that's why these restructuring support agreements have to give the debtor that same fiduciary out as it has if it was, proposing its own deal to creditors. It was a long-winded answer, but
no, I appreciate it, Eric. I think that's an important aspect of these matters, and I wanted to make sure everybody heard what it was about.
Well, and it's something interesting to think about too, Tom, because as a on the creditor side, which is why speed sometimes is something what you want. If you do really feel like this is a good deal for you to get some equity in a debt equity swap, for example, you want to move quickly, because the longer things take, the more likely an alternative comes up. And it might not be better, but then there might be a fight about whether it's better. And that can be costly and disrupt the strategy you want to do. So the final category that we have of restructurings are kind of the traditional or the free fall, where the debtor really doesn't have a reorganization plan, or might have some ideas, but it hasn't really negotiated to a large extent, and it has to file bankruptcy. It needs the automatic stay because of some kind of liquidity event, liquidity crisis, or some other sort of, we've called it a liability crisis, which be cases like the asbestos cases or the abuse cases in the Archdiocese or the Boy Scouts, where they really need bankruptcy to help, fix those liability issues. Those are cases who maybe there have been some negotiations that occurred but broke down, or they really haven't negotiated because the creditors are too widespread and they really can't bring people to the table without the public process of the bankruptcy court. And these things can obviously, on the quick end, are going to be longer, 4 months, 5 months, but they can be, years potentially. And again, we're excluding kind of the sale scenarios because these sale cases are kind of its own unique animal. We're talking here plan type cases. So that's the free fall traditional type of restructuring. So let's talk a little bit more specifics about when a pre-pack will make sense as opposed to these other 3 different categories that we talked about. So why does it make sense? Well, one, a pre-pack, it utilizes the bankruptcy process, which is different than out of court. So you can drag people along into it, even if they're not on board. And it's of those court proceedings, it's going to be the shortest and most effective, cost-effective process. It's going to give you a certainty of outcome in the bankruptcy case because you pretty much know that you've got the votes and you've got the support of your creditors, and that, barring some issue on feasibility or a value fight by some dissenting creditor, you're probably going to, be okay in front of the court. And a higher probability of a positive outcome on day one of the case. Where this works best is when you have a smaller group of creditors who are going to be impaired, right? If you've got hundreds and hundreds or thousands of creditors who are impaired and you need their votes, kind of hard to solicit that and negotiate that without a automatic stay in the bankruptcy process. Hard to do that out of court. You still probably want an RSA in the early stages of this to try to get people in your camp and as a borrower locked up, if you will, and vice versa to get the debtor, except for the fiduciary out, on your side on the deal. Because if you don't quite get into the full pre-pack, you at least have a pre-negotiated deal and you can file and then implement it in the pre-negotiated type transaction. And the pre-packs, they don't work in sales and they don't really work in an operational restructuring. So if you need to shed a bunch of leases or really bad contracts or things like that, pre-pack tends not to work. It doesn't mean that you can't reject a lease or can't do some operational things in a pre-pack case. But if your case is really about operationally using the bankruptcy code and rejecting agreements or selling certain assets and things like that, pre-pack doesn't work that way. There's too much notice and objection requirements and other things like that that you need to work through the bankruptcy process through motions and hearings and so forth, that you can't really wrap that up in a bow and just do that in a pre-pack. The other thing that is an issue with the pre-pack potentially, which is why you want a small group of creditors, if someone doesn't like what you're doing, they may push you into involuntary in an unfavorable venue, right? If you're not treating trade 100%, they are not going to like a pre-pack. They may sue you in a jurisdiction that might be more favorable to them. You think about like the automotive cases, right? They all filed in New York. If they were trying to do a pre-pack, they could have had an involuntary in Detroit. They didn't want to be in Detroit. They wanted to be in New York. there were only 100 people protesting the GM sale in New York. There would have been tens of thousands of people protesting the GM sale in Detroit. So there's a reason why management and the lenders, i.e. the government, wanted to be in New York. So to sum up, when this makes most sense, smaller groups and really small groups that are impaired. So unsecureds tend to just ride through at 100 cents on the dollar, and the bankruptcy is a non-issue for them.
Let me ask a follow-up there on that as well. I have not seen a pre-pack where the trade creditors were impaired. It would be very difficult in most circumstances to line the trade creditors up in advance. Have you seen that? Are you aware of cases where they have had impaired trade creditors and still made a pre-pack work?
Not in a pure pre-pack. Joe, have you seen? I can't recall that, because the problem is if the trade is if trade is impaired, then as a class, they get to vote. Even if you have another class that gets to vote, and therefore, you could cram or something like that, they would still get to vote. Unless, I guess you would say the fulcrum debt was like at a second lien, or mezzanine or something like that, debt level, and that trade is getting wiped out and getting zero, so they're not entitled to vote and deemed to reject. But if you put that document out there in the public, because you're soliciting your pre-pack votes, and you're a trade lawyer and you realize you're going to get zero or not 100 cents, you're going to start trying to disrupt that, and you're going to end up in an involuntary scenario. And that's why I have not seen it, or I'm aware of it. I don't know, Joe, or Peter, if you know of that, of a pre-pack in which there was impaired trade.
I would think that's a high risk of being an unsuccessful pre-pack, like you said.
Yeah.
Yep, not that I've seen.
Yep. Okay. All right. So let's talk about timetables, because this is kind of an interesting thing with a pre-pack. So here we've put on a little chart that just gives you the regular timeline, if you will, of a bankruptcy case. And this is kind of the traditional free fall category that we showed. And you have a pre-petition filing preparation, which can usually a couple months or a month on a normal operational case will give you enough time to kind of prepare the bankruptcy. But it can be a lot longer, of course. The Boy Scouts, for example, retained Sidley Austin in October of 2018 and filed, in February of 2020. I was about to say 2019. I'm getting my years mixed up. So over a year of pre-petition planning, where they tried to do a pre-pack, which failed, and then have a regular case now, which will take a while. Then you file day one in a traditional case, and you have your first day hearing, and you have it, stabilize the business both in the court and on the business side, which will take you a couple months in that scenario to go, to get that implemented. And then you start negotiating, which could have happened pre-petition, with creditors. And that can take, who knows how long. Could take you a little bit of time, could take you a long time. Then once you have that business deal, or you think you have a deal that the creditors can accept, or enough creditors will accept, you got to file your plan and disclosure statement. You have a deadline, debtors have a deadline to file that, which can get extended, but there's a drop dead date of 18 months. You can't get extended further than that. You usually need 28 days notice, but you do a little bit more between the disclosure statement filing and plan filing and the disclosure statement hearing. And then the second hearing after disclosure statement is approved, then you, move forward to confirmation. Again, 28-day notice, but you tend to do a bit more than that. So that's usually, we like to say, about a 3-month process in a normal case. Plan's confirmed, and then you exit bankruptcy. So it's something on the quick side, 4 months would probably be a quick Chapter 11 traditional plan case. And then on the long side, who knows how long, it could be much longer. So that's kind of your typical timetable with lots of caveats. So it could be, all over the place. So what happens in that regular timetable when you think about in a pre-pack, pure pre-pack. So that's the next slide, Peter, thanks. So in the pre-pack, a lot of those things in the timetable are actually done before you file bankruptcy, in terms of negotiating with the key creditors. Well, a lot of times you're doing that in the bankruptcy case. Pre-pack, you do it all before. You typically have confidentiality agreements because they're going to want, these bondholders or lenders are going to want certain financials and different things like that to kind of understand what the deal should be. They'll have advisors, typically on top of the debt advisors, and so you're going to have NDAs to get that those kind of that kind of information necessary for the due diligence. And then you're going to, best practices would be to get an RSA executed as a template for the plan and disclosure statement. You're going to then draft those documents, finalize them, solicit those documents to get votes, have objection deadlines, get voting deadlines, get those deadlines in, and then you file bankruptcy, and then you move to confirmation and to exit bankruptcy. So when you look, in fact, Peter, if you want to backtrack one slide, thank you. So if you look at this timeline here, where you've got the blue of the filing and the traditional one, that blue day one bankruptcy filing is going to be all the way just right before a confirmed plan, right? It's right before that confirmation hearing is where that actual filing date happens. So all these other boxes will be happening before. So one thing that you've kind of seen, and I think here is an example of a pre-pack that's, one more, please, Peter, thank you, which was in the Southern District, and this was kind of their, this is from their pleading, so we have to give them credit for a nice graph. Of all these things in the blue that happened before they filed, the blue being the petition date, and they negotiated, they had their drafting and so forth, and then on January 4, when the deal was done and all the documents were pretty much there, boom, they moved forward with notice, with solicitation, with voting deadlines. With the plan supplements, which are all these ancillary documents that are part of a restructuring deal, and then including objection deadline to the plan, and then they filed bankruptcy, and then the next day they had a combined disclosure statement approval and confirmation hearing. So they spent basically one day in bankruptcy and did all this stuff before. And so that's what we kind of are calling we've termed the ultra expedited prepacks, which are kind of a unique thing. If you can go to the next slide, Peter. It's, we've got a couple of examples, where they literally are in bankruptcy for a day, for a week. I mean, these are extremely fast, and Fall Beauty is great. And we've got a little quote here in terms of the basis, where the U.S. trustee was arguing more notice, you can't go this quickly. And Judge Drain was basically saying, where does there need to be a compelling reason to have a very fast pre-pack? And before the U.S. trustee could even answer, he shut him down and basically said, it doesn't say it anywhere. It's a false standard to require a compelling basis to have an expedited pre-pack, and that there's no reason you can't have a pre-pack file bankruptcy on day one and be out of bankruptcy on day two. That is more of a New York thing. I don't think that is something that will happen nationwide. I think there's lots of courts, including Delaware, who might not allow a one day in bankruptcy now, who kind of maybe feel like a little bit more notice in the bankruptcy process would be appropriate. And I think some of those courts would argue, what's the true harm of waiting, 30 days between filing and confirmation hearing in the traditional pre-pack timeline versus this 1 or 2 or 5 days in the ultra expedited pre-pack fact pattern. And, you could argue the business, you could argue something, but I'm not sure that that carries weight, because the business is always crumbling in every bankruptcy case. And the reality is it's not always true. Although, in some cases it is. So let me then pass the virtual podium here to my partner, Joe, who's going to get a little bit more into nuts and bolts of the pre-pack requirements, me having set up kind of the 30,000 foot intro. Joe, take it away.
You press unmute. Thanks, Eric. I appreciate it. So I'm going to get a little more down to the bottom, grass level, fine details about how to do pre-pack. It's not extremely difficult once you follow the rules. There are not a lot of rules governing prepackaged bankruptcies. Few code provisions, few bankruptcy rules, and it's primarily relying on the Chapter 11 rules. And this is ironic because the history of prepackaged bankruptcies goes back, to the middle of the 19th century. But the first enactment occurred in 1978 with the passage of the code. Still not a lot of rules. Next slide, please, Peter. Eric talked a lot about restructuring support agreements. I'm not going to touch on it too much. It's the key path to getting towards a prepackaged plan. You got the key commitments, but an RSA is not a light document. It generally tries to bind a debtor to certain key documents like a plan and disclosure statement, funding documents, pertinent court orders, and it usually includes milestones, which says, okay, in 10 days you have to do this, in 20 days you have to do that, in 30 days you have to do that. And it does that so that it can obtain some certainty over the process. A lot of RSAs look like a plan and disclosure statement, so they have to, add that caveat in addition to the fiduciary out that Eric talked about, that this is not a plan or disclosure statement because the bankruptcy code says that there are certain ways that you have to ask creditors to vote in a plan. If you don't do it those ways, then their acceptances are not counted. Next slide, please, Peter. One thing of a pre-pack is, as I mentioned before, is that it has to meet the same Chapter 11 requirements as a regular Chapter 11 case, like a free-fall case. So in Chapter 11, 1129 governs the plan confirmation requirements. There are 16 broad requirements. One of them is really comprehensive, which says you have to meet the other provisions of the code. So that ties in the other provisions, which are enormous. But there are 16 generally. But pre-packs are primarily, the unique concept of pre-packs is the voting that occurs prior to bankruptcy. It addresses all that voting prior to bankruptcy. Next slide, please, Peter. The other concept is part of voting, or essential part of voting, is a disclosure statement. That's how you ask people to vote. It's this large document that describes a plan, describes the history of the debtors. It tells you how the debtors got into bankruptcy. It gives you evaluation of the debtors once they exit bankruptcy. It demonstrates how the plan meets the best interest of creditors through a liquidation analysis, which compares the recovery in Chapter 11 versus the recovery in Chapter 7. It gives you projected financial information to show that the plan is feasible and the debtor won't have to file bankruptcy again. And it goes through all of the solicitation procedures, how they're going to vote, who's impaired, who's not impaired, tax consequences of the plan, and the risk factors. And then it asks you to vote for the plan. Next slide, please, Peter. So on solicitation and voting, you have to include generally three things: the disclosure statement, the plan, and the ballots. There may be one or two more things, like a letter from a creditors committee or from a plan proponent that says, please vote for the plan. We think it's in the best interest. There's also the concept of record date, which is hugely important with public debt. Public debt could trade millions of times over on a daily basis. So the bankruptcy code requires you to establish a date where you're going to record the people that are actually going to vote on the plan. That is included in part of the disclosure statement. You have to establish that date. And generally, it's close to the time you file bankruptcy, because you don't want to get people that weren't impaired or not really impaired by the plan to vote on the plan. Now, when I mentioned that there are very few provisions governing prepacks, the ones in red over here on the slide are really the provisions that are governing prepacks. 1125 says You can start soliciting people prior to bankruptcy. Like I said, this concept came out of equity receiverships back in the 40s, where they did it prior to actually initiating a proceeding. There's 1126B that says that if the acceptance occurred prior to bankruptcy, if it complied with applicable non-bankruptcy law, and what that means is state public securities laws or the Securities Acts of 1933 and 34, that the disclosure statement will be fine. The acceptances will be deemed acceptable to the court, and you can confirm a plan. Bankruptcy Rule 3018 also says that you're not going to allow acceptances to be to support a plan if you don't have record holders that are voting on it, and if you're not disseminating the plan and the solicitation package to all creditors of the same class, and if the voting period is too short or the disclosure is inadequate. There's another rule, 1121A, that says you can file a plan on the same day of confirmation, on the same day you file your bankruptcy, your petition. And that's also part and parcel of the pre-pack. That's what happens. You essentially file a plan and disclosure statement, but you did all the voting and everything prior to filing bankruptcy, but you file all of that with the court the same day you file bankruptcy. Next slide.
Joe, can I stop and ask you a question here?
Sure.
On the 1126B question, the statute says you have to comply with applicable non-bankruptcy law. If you are dealing with claims that would not otherwise constitute securities for purposes of the securities laws, do you still have to comply with the securities laws, or does a different rule apply under those circumstances?
That's a great question. It's mostly for the securities laws that are not exempt under the Securities Act. So a lot of times you have publicly traded debt that has an exemption under 4A of the 1933 Act, and you don't have to comply with securities laws. So a regular trade claimant, you don't have to comply with securities laws. What happens there is you comply with Section 1125, which is sort of modeled after securities laws, but not as complicated, and says you have to provide the creditors with adequate information, but it's not as comprehensive as securities laws.
And that same situation would come up with bank creditors, whether traditional bank creditors or whether you're looking at one of these newfangled bank debt packages where the actual creditors can be funds and insurance companies and anybody else who can squeeze together about $2 million to buy a piece of it. So, I mean, there are a lot of circumstances, including the ones I've been involved with, where there was no need to solicit under the securities laws because the outstanding debt was not securities and the outstanding equity was not voting either, because in one case it was being passed through and in another case it was being wiped out.
And you also have good securities lawyers, Tom. Next slide.
Well, I'm not worried about having the right tools here at Dorsey, but which ones have to be applied is the question.
Yeah. Well, I rely on my securities lawyers whenever I come up with these situations. Besides the disclosure requirements of adequate information and the plan, you have notice. Bankruptcy is a lot about notice, and there's a quintessential notice deadline, which is 28 days. In a regular free-fall bankruptcy, you have 28 days for a disclosure statement hearing. You have to give all creditors 28 days to object to the disclosure statement and notice of the hearing. And then another 28 days for plan confirmation. So that's how you get to Eric's timetable of 60 to 90 days to confirm a plan. Those 28 days are essential. What ends up happening is you end up collapsing that, and you just give parties 28 days. In a pre-pack case, you give parties 28 days for the plan and disclosure statement hearing and objection deadlines. And you do that after you file the bankruptcy. You also give the U.S. trustee, all the rules require the U.S. trustee have knowledge of the disclosure statement, the plan, and objections. And if you're doing injunctions that are not permitted by the bankruptcy code, sometimes there's third-party releases that are included in a plan. You have to include specific language, and that's part of the noticing requirements. Next slide, please, Peter. Court
And-
approval is
and-
always essential.
Joe, let me just jump in. I was going to say on the noticing piece, and so that's kind of, I think, why some of these courts, Delaware and others, are going to say, let's have a month here in and out of this case, while New York's saying, look, I'm going to shorten that time, that 28 days, because why not? Like, you gave everyone plenty of time to object pre-petition. Anyone who has an issue should have done something, and why wait 28 days? What's the point? And it's a little bit more, who you're thinking about, the pro-debtor side or the pro-creditor side. And I think that New York's being a little bit more pro-debtor, pro-plan supporters, while Delaware is being a little bit more like the person we haven't heard from yet. Let's give them a little time to raise an objection.
New York is, you're right, Eric. New York is a unique venue because it's had special laws governing pre-pack since 1999. So it's a leg up before everyone else. And those laws are very elaborate. I'm gonna talk about those in a second. And it's sort of like someone sat down and thought about, okay, how do I employ all of this? Most of the jurisdictions don't have that. Although Delaware, and you're familiar with this because you practice a lot in Delaware, are very familiar with pre-packs, that they kind of fit them within their local rules. I know for the Southern District of Texas, which is closer home for me, there's maybe a couple of specific rules and the complex rules that govern pre-packs, but New York has a very extensive rule, and that's how you get a 24-hour bankruptcy ultra pre-pack. Court approval is essential for everything. The biggest thing I'll tell you here are that you get court approval after you file the bankruptcy. Normally, you first say "Mother, may I," and then you file the bankruptcy. Before you get a disclosure statement hearing, or before you get a plan confirmation hearing. But with the pre-pack situation, you tend to try to do everything correctly, predict what the court would do, and then on the first day, you ask the court for permission that blesses everything that you did. Next slide, please, Peter. Publication notice is also very important. As we talked about public securities, a lot of times public securities are owned in a trade name. They're not owned by the actual owner. And that's for a lot of reasons. The owners don't want to disclose what kind of securities they own. So how do we get notice, the 28-day notice that the bankruptcy code absolutely requires for a disclosure statement hearing and a plan hearing? Well, Rule 2002L says that you can do publication notice. And publication notice essentially looks like this. I'm not kidding, the fonts are not very much bigger. These are a couple of cases we've been involved in, but you put that in a newspaper that often investors look at. For example, Denbury was the Houston Chronicle and the, I think, New York Times. Full Brands, I think, was Wall Street Journal and some other popular investor publication. But it ends up giving you that type of notice. And unless you're understand where to look, or you're been a sophisticated investor, you're just going to skip over this notice. But bankruptcy courts have taken into consideration the practicalities of having to serve hundred thousands of claimants, hundred thousands of interest holders, and this is the best they can come up with to try to comply with due process. Next slide, please, Peter. Like I said, New York has very elaborate procedures. They go down partial pre-packs. They go down what happens if they file bankruptcy while I'm trying to do a pre-pack, how to do a scheduling motion on the first day, what happens, what the acceptable voting deadlines are, 21 days for publicly traded securities, 14 days for non-publicly traded securities, which is what Tom was talking about, 21 days, for everyone else. It tells you when to coordinate with the U.S. trustee. But in practicality, if you're going to do a pre-pack, you're going to coordinate with the U.S. trustee a lot sooner than 3 days that the local rules require you to, because you need them on board. You don't want anyone objecting. You want to make everyone happy prior to filing bankruptcy. And next slide, please, Peter. The other thing I would say about pre-packs, the downside of them, is that there's a lot of protections that are waived when you do pre-pack. Now, if you're the borrower's counsel, or debtor's counsel, you think it's great, you get it done, it's cheaper. But if you're creditors, you're thinking, okay, well, I don't get to question the debtor. why he did this, why they did that, and why they did that. And I think the rationale is that you've gotten their vote or most of their votes, you're leaving them unimpaired, so they shouldn't be able to complain. But I think it's a detriment to some parties because that invariably you're not going to get 100% of the parties happy about the plan. Invariably, there's going to be some parties that are not fully satisfied in terms of all their rights. And I think the other disadvantage is a lot of jurisdictions just don't have local rules like the Southern District to kind of give parties in advance notice of what's acceptable in terms of due process notice and voting and things of that nature. So all in all, prepacks are great. I don't want to say that wrong, but if you're a dissenting creditor, you're going to waive these protections during that process. Next slide, please, Peter.
All right, I'm going to take a break here and go through some questions. And I know that the answers have been provided already by others on the panel, but they were only provided to the limited universe of the person who asked the question and the other panelists. So let me just go through these. There's 4 of them. The first one, have any DTC record holders been held liable for not passing notice on to the beneficial holders? And this would be notice of the filing of the plan and the disclosure statement. And Eric, you want to respond to that?
Yeah, I would say I'm not aware. So I guess the issue is, there's a solicitation process and, DTC, which is supposed to issue out these notices to the beneficial holders who are holding it, in street name, and and they don't pass it along, or they don't pass it along in time. I think it's probably the more likely scenario. I'm not aware of liability on. I don't think it's really that much of a borrower problem, because I think the publication notice is the backstop for adequate notice having been given. So if some holder down the road shows up and says, I didn't get actual notice because my agent didn't send it to me appropriately, my broker, I think the court would be like, well, there was publication notice. So, if you were paying attention, you would have known. And but I'm not aware of that that DTC problem. I don't know whether anyone, Peter or Joe, whether you've seen that. And Steve Heim, I don't know whether you've seen that. I guess you're asking, so you probably haven't. So, go ahead, Tom.
All right, the next question is, if a bank is the only secured creditor and there are only a handful of unsecured creditors, is this, meaning the pre-pack, a good option?
Well, and this actually is going to answer, I think, one of the other questions that was sent to us, which was, can you get everyone to forbear during the negotiation process in the pre-pack? And the answer is usually yes. And this is one of the examples where you have one lender who's really involved in the pre-pack and no one else is. Or you have a group of bondholders who represent 90% of all the debt, and those 10 bondholders are all represented by one ad hoc committee and one law firm, right? And why would they all band together, or why would this one creditor agree to forbear and negotiate? Because at the end of the day, they're going to be bankrupt anyway, potentially, or it's out of court. And it's most efficient for them, since they're the biggest stakeholder, to do this efficiently and less costly. So why not sit down and forbear and have a conversation and see if you can work it out in a cost-effective manner. If you can't, all right, fine, then we'll file bankruptcy and we'll have a little bit of a fight about it. But if you can do it this way, then let's do it this way. It's just kind of like litigation, right? Before you sue, you might want to have a conversation and enter a tolling agreement to see whether you can resolve the issue, because that's better for everybody, plaintiff and defendant. And if you can't, then you move forward. And that's, I think, the way these things a lot of times work.
And that's certainly consistent with my experience too. The major creditor groups, the ones who are participating in the negotiations, will forbear prior to the bankruptcy. And Joe, I think you said in your answer that that's your experience as well.
I completely agree. And I probably answered it in a way that said like a formal forbearance agreement. You really only obtain that from a bank or major constituents. You don't try to obtain that from smaller creditors. There's just too many out there, and everyone wants the last piece of the pie. So, but they're going to forbear in terms of not initiating a lawsuit, especially if you can convince them, well, look, if the bank wanted to, it could take everything away and you'd be left with nothing. So I think it serves your interest to try to play with everybody.
Yeah, that's a good point, Joe, because I think the forbearance for a bank that, especially, you have an account control agreement, you're holding the borrowers, the debtors' cash. You want that forbearance because the bank, if you're in default, can just sweep and cripple the company instantly. If you're a bondholder, unsecured bondholder, what have you, yeah, you're going to file a lawsuit and then the company will answer or move to dismiss. I mean, you can't cripple the company in a nanosecond. So you don't really need, the borrower is not going to need a formal forbearance from that group because it's going to take them so long to actually cause real chaos for the company. So, it's almost like a handshake. All right, we won't sue you. And sometimes they sue in the middle of those negotiations to try to push some pressure, and maybe that causes a filing. Who knows? It's a million different options.
Let's go forward with the case studies here. First one is the Pennsylvania Real Estate Investment Trust, or PREIT, which is a case that I'm working on right now, and I had thought that it would have emerged from bankruptcy by the time we had this presentation, and I turned out to be wrong. So I'm going to talk a little bit about this case, but only things that are of the public, in the public record, because of the fact that the case is still ongoing. Pennsylvania Real Estate Investment Trust is, as the name indicates, is a REIT. It's a mall REIT, so it owns a lot of properties that are underperforming right now. And the company negotiated with its principal creditors to come up with a plan, traditional pre-pack. In this case, it was a little different than most pre-packs in that there wasn't really a balance sheet restructuring per se. Equity passed through the case. And what happened in the case is that the bank lenders agreed to give PRE a little bit more time and a little bit looser covenants going forward, and the opportunity to take another shot at turning the business around in exchange for taking collateral. So what the creditors were getting out of this was not any kind of payment, but they were getting essentially a lien on all the company's assets to secure the bank debt. But as a mall REIT, PREIT also had some property level funding at a couple of their malls. One was a joint venture, and one was they were the sole owner. But those were not brought into the bankruptcy case, and those needed to be restructured at the same time as the corporate debt, and that had to take place outside of the bankruptcy. And turned out to be much more of an effort, I think, than what they had assumed. And I guess the lesson from that aspect of the case is, if you're going to do a pre-pack, make sure you got everything in the package. If you don't have everything in the package, it's not necessarily going to work. This was also a case where you use the pre-pack because you don't have unanimous consent from all of the parties. If all of the lenders had signed up to do the restructuring, it could have been done out of court, because the equity wasn't being affected, the trade wasn't being affected. The only people who were being affected were the lenders. And in this case, they got 90% of the lenders to sign up for an RSA, but not 100. And that meant the case had to be done through bankruptcy because you got dissenting creditors. They ultimately ended up getting 100% approval for the plan by the time of the confirmation hearing. But at the time of the filing, they didn't have that. So that's another way that a pre-pack is a valuable tool if you have a strong majority but not unanimity for a plan that extends maturity or otherwise would require 100% vote under the relevant documents. The final piece about PREIT, which is interesting and shows that there can be disadvantages as well as advantages to this, is that the way that the PREIT decided to treat the guarantee claims, which was the claims of the mall level lenders that had, payment guarantees of at some level from PREIT, is they let them pass through the bankruptcy unimpaired. And that, for that reason, they were able to treat that class as unimpaired and not entitled to vote. But in fact, what the plan did is it gave all the collateral to the bank creditors who had been pari passu with those guarantee claimants and are now going to be senior under the plan. So the guarantee, we didn't have any fight from any of the guarantee claimants, but the fact of the matter is they could have come in and argued that they weren't being treated the same way as other unsecureds who were at the same level. And therefore it could have gone differently if those guarantee claimants had not decided to allow it to go through. So those are the lessons that I take out of the PREIT case. Pace Industries is another case that I was involved in, another Delaware case. I'm glad to have Delaware cases or Texas cases because I have a real bankruptcy lawyer to help me with them.
Hey, Tom.
Yeah.
I hate to jump in. Let's skip to Peter's case study
Sure.
because we're running a little bit low on time.
Yep, that's a good point.
I want to
Go
get
ahead,
into
Peter.
that one because it's not that Pace isn't interesting, but go ahead, Peter.
Thanks, guys. Yeah, so I'm going to talk a little bit about Carlson Travel. For those local in Minnesota, you certainly know Carlson and its primary operating subsidiary, Carlson Wagonlit Travel. They are a global travel agency. They, in addition to doing corporate travel, they do events, they do conferences, they do exhibitions, they do large scale travel and entertainment. So as you can imagine, COVID did not work out well for them. And it severely impacted their business. And as was the case with the travel industry, it happened almost, overnight. And it put the Carlson global travel empire into a real difficult position very quickly. They realized almost immediately, as did their primary lenders, that there was going to be a serious issue beginning around the summer with covenant compliance. They had three major classes of debt. They had a fully secured commercial bank credit facility, as well as senior secured notes that were both euro and US dollar denominated, and then they had unsecured notes. And I think they began lobbying efforts right out of the gate to work with their lenders to figure out how to best manage the process. Carlson is a privately held company, and actually Dorsey in this case represented Carlson Inc., which is it's a privately held company that that ultimately was 100% owner of the travel business. Amongst they've got a number of other investment activities as well, and so Carlson Travel as well as Carlson Inc. worked together with the creditors to figure out what they could do to try and facilitate an out-of-court restructuring. The original goal was to keep the business running and to try and avoid any disruptions. They were in the midst, as they constantly are, of negotiating long-term contracts with providers, and with all the uncertainty in the travel business generally, it was a time when they really wanted to avoid being in bankruptcy and giving their competitors any sort of competitive edge while they were, seen as being vulnerable. So, after some some long negotiations, including waiting to see if the government was going to come up with funding similar to what they provided to airlines. When it was clear that that funding wasn't going to be forthcoming, they roadmap pretty much exactly what Eric and Joe have previewed for us. They had an extensive and very detailed term sheet with the negotiated business deal, which involved the owner, Carlson Inc., putting in $125 million of new equity. It involved existing bondholders signing up to purchase $125 million in new money notes. It had the secured creditors, the commercial banks, agreeing to allow all of these changes and the incurrence of new debt to happen. And it wrapped all of those, pretty complicated terms with a lot of tax structuring on top of that into a very thorough, detailed, and hefty RSA. The RSA negotiations, because of the level of detail of the transaction, because of the tax implications on both the company as well as the parent company, it really, sort of made for an interesting RSA negotiation process. But, when you narrowed it down, similar to what was being discussed about, making sure you've got the right number of creditors, at the end of the day, there were about 12 bondholders that had about 85% of the debt. They held them in multiple funds, which is pretty typical, but, that you were really dealing with about 12 entities. They were the ad hoc committee. They were also the backstop committee because they were the ones agreeing to buy the new notes. And so, there was a backstop agreement that was put in place to ensure that there was enough support to actually, purchase all the new notes that needed to be purchased. There was an equity contribution agreement that was put in place that was there to ensure that the $125 million went in. There was a whole negotiation on a shareholders agreement because a new entity was set up in between Carlson Inc. and Carlson Travel to ensure that that the new money notes purchasers would get equity in the new entity, which was part of the business deal, adding to all of the complications that Joe and Eric talked about earlier and that Tom addressed with his question of what about the securities issues? This is a privately held company that was now issuing securities, under registration exemptions, but we had to manage through that process, the solicitation process for the consent for the exchange, because all of the existing notes were being restructured. Pretty much textbook, everything that these guys laid out needed to happen, happened. At the end of the day, the consent solicitation was launched, the offering memo, and the offering was launched for the new equity and the new debt. And then we sat and we waited, and the company was very eager to keep this out of bankruptcy. But, in the event that it needed to go in, there were really two drivers for what could have caused that. Driver number one was what Tom talked about, which was, could they get all of the consents required? They were pretty sure they could, but that wouldn't be known until the end of the solicitation period. And issue number two, which was an interesting issue that I think has become very prevalent this year, given the rapid decrease in business for so many businesses due to COVID, is what's the cancellation of indebtedness tax analysis. And one benefit that an owner of a business that receives a significant modification to its debt and might otherwise incur tax liabilities on that forgiveness of indebtedness, if it is treated as such, can do is they can rely on an insolvency exception. And one way to prove up that insolvency exception is to run through the prepackaged bankruptcy. So those were on the outside, but at the end of the day, there was enough force and enough consent and enough interest in the new product that was being sold through the consent solicitation and the offering memo that they were able to pull this off out of court. But the pre-pack and all the plan documents were included as part of the consent solicitation as well as in the RSA. So it was fully negotiated. It was outlined just the way it was described in this presentation. Unfortunately for the company, it was not needed. So I know we're running low on time, but
Can I ask
Tom?
you one question, Peter?
Yeah, please, Joe.
In your experience, this seems like the typical case where you're trying to do a workout at the same time. It's like parallel paths.
Correct.
And the pre-pack.
Yeah, it very much was, and I'd say there were probably about 3 months of workout negotiations, and it happened so quickly, and COVID impacted this business so dramatically that the covenant compliance issues didn't even come up till, but they knew what was coming. They saw the cliff, and they were very proactive in trying to maintain and preserve, partly because it is such a strong relationship business. They really needed to protect their place in the market. And so it was absolutely, though, a workout and a pre-pack and a RSA negotiation were all happening simultaneously, all while waiting for government money that never came.
And that's a lot like PREIT. I mean, PREIT had literally an RSA with 2 term sheets, one for an in-court and one for an out-of-court restructuring. And Peter, were they able to get 100%? Is that why they were able to do this without a bankruptcy?
They didn't need 100% of the bondholders, but they got over 95% of all 3 classes of bonds. They did need 100% of the credit agreement lenders, and they got that, although that was a very, because it was an international deal that needed to close in London before it closed in the US, it was, it made for some very late nights / early mornings to get the closing and get those final consents in, and people definitely waited to the very end.
All right, we are 2 minutes over. I don't know if folks want to stay on and hear about the other 2 case studies or not. If you don't want to, thanks for joining us, and feel free to exit now. I will quickly cover PACE and then let Joe cover Denbury for those who want to stay. PACE was a classic pre-pack. It was a balance sheet restructuring, debt converted to equity. You had a senior revolving line secured by the current assets that passed through the bankruptcy. They had to put some more money in, so they had to vote for it. But the bottom line is that that isn't where the action was. You had term lenders who had some fixed assets in junior position on the current assets. They got some senior term debt, and they got some equity in the transaction. Original equity was wiped out. That's also not an unusual set of circumstances. What was unusual in PACE is that you had common equity, which was willing to go along with a plan that wiped them out because they got some other things they wanted out of it. And then you had a preferred shareholder who did not want to go along. And that preferred shareholder under the certificate of incorporation had a blocking right. Bankruptcy couldn't be filed without their consent per the certificate of incorporation. The board decided to file bankruptcy anyway, and the preferred shareholder objected. And the big issue in the case turned out to be that preferred shareholder's right to block a bankruptcy filing. The bankruptcy court ruled for the debtor, ruled that the preferred shareholder, I mean, it wasn't 100% clear what the ruling was, but it was either the preferred shareholder had a fiduciary duty to all of the parties which it had not honored, or there was a public policy problem with letting a blocking position be in the hands of one party in interest who did not have a fiduciary duty. Very interesting case, not so much from the pre-pack perspective, but from the perspective of that issue coming up and being decided by the Delaware Bankruptcy Court in a manner I at least didn't expect it to be decided.
And I think one thing just to add to that case is it was a bench ruling after a long hearing. So, a little different than a more carefully crafted opinion, which is hence Tom's analysis of not sure what the actual ruling was. Is, well, if you read the transcript, it's a little confusing about whether was it A or B or a combination of the two, but such is bankruptcy.
I am going to quickly go through Denbury. It's an exploration and production company. I'm sure we've seen a lot of those lately. It was a pre-pack, partial pre-pack, and I'll explain what that means. But it's a classic case of a balance sheet restructuring where you took about $2 billion in debt and you converted it into equity. And the company comes out of bankruptcy, $2 billion leaner. So they got out of bankruptcy in 35 days. But the unique aspect of it, the partial pre-packed aspect of it is not everyone voted prior to bankruptcy. Because of these securities issues, they were going to have to get the equity to vote on it. And so they wanted to avoid securities issues. Well, when you file bankruptcy, Section 1145 exempts you from securities issues and puts you back into the realm of Section 1125, which says all you need is adequate information and a disclosure statement, and that's all you need to allow people to vote. So they elected to solicit all of the unsecured bond debt prior to bankruptcy, which is again exceeded $2 billion. They fell within an exemption, even though they were publicly traded, so they didn't have to comply with SEC laws. And then as soon as they filed bankruptcy, they asked the court to solicit the equity holders, and they did so and still were able to leave bankruptcy pretty quickly. So good example of a balance sheet restructuring. Consolidates everything what Eric started with. It's you need several groups here that concentrated groups that can vote quickly. You leave one class like the trade creditors that are divergent, unimpaired, so they can't complain. That means they don't have to vote. You don't have to ask them for permission. And when you file bankruptcy, you're almost ready to go. So interesting case and good example of balance sheet restructuring.
Thank you, everyone, for joining us today. And we will be having another roundtable in January. We're getting that topic together now. And look forward to seeing everyone in the new year and at some point in the new year in person. Thanks very much.